Hi, I'm Dave Wurzel, and you're watching PHTV4. This is Spotlight Issues, exploring today's topics. And specifically on this show, we're going to take a look at how one becomes a judge with an eye on the Supreme Court nominee, because that's in the background of this story. The different philosophies involved in interpreting the law, just as a kind of a historical context for us, which I found very interesting. So the Justice Branch gets formed in 1789, and they first convened in 1790. And I read that there were, so from 1790 to 2020, we've had 17 Supreme Court justices, and we've had 114 justices. And to me, that makes this kind of an extraordinary time. Within the last 4 years, we've had 3 nominees to the court. I mean, that's a significant contribution. So as we kind of navigate what's involved in becoming a judge and interpreting law, we have a special guest with us today. I'd like to welcome retired Judge Susan Snow. Thank you for joining us.
Thank you for having me.
You were in a state circuit court, is that correct?
Correct.
Okay, and at some point we're going to have to distinguish between state court and federal court, but maybe before we get into those other topics, can you give us a little bit of your background?
I'm an Illinois attorney, retired, and I practiced law with my dad in Cook County. And my dad was very active in real estate practice, and I, as an attorney, developed an interest in domestic relations or divorce practice at the time. And although I was very young, I heard people saying to me that I should try to become a judge. So I became a judge in 1981 when I was 34, and left my dad's practice behind. But I think, having worked with my dad, I mention this because his influence on me came from his personal philosophy, which was to help people. And so I really was born into a family that was more in line with public service, rather than becoming a lawyer to make a lot of money. So
when did you feel like, yes, I want to be a judge, I want to be the person on the bench, as compared to the person on the other side trying to, establish a position, let's say?
I really was almost surprised by the initiative with people trying to help me become a judge. So I can't say that I had a long-term aspiration, but as I started to work on the project of becoming an associate judge in Illinois, which we should probably describe for the viewers, it came to me, I was growing into it, but those first years of sitting on the bench were the ones where I really understood what it was all about.
So I think that's a good transition then, to take a look at, how do you become a judge? Let's pretend, like in your case, you were practicing law and then you were kind of channeled to it by other people, it sounds like. What if, I don't know, somebody's college bound out there and they think, I want to study law and I would like to sit on a bench someday. Let's talk about the state level first, maybe. How do they pursue that path? How would that happen for that person?
In Illinois, you are required to be a lawyer and be of a certain age to be a judge, and it's certainly fair for young people to aspire to become a judge, but you'd have to become a lawyer first. And it is recommended, especially in Cook County, where I practiced and became a judge, it's recommended that you have practiced for 8 years before you're even considered. Now, that doesn't really happen so much anymore as we restructured the judiciary in Cook County and we have sub-circuits. There were many openings where practicing lawyers did not even live, and so the people who submitted their names for judiciary hadn't practiced 8 years. I, at my young age, had just barely gotten 8 years of practice in. So that's part of thinking about becoming a judge. But what you really need to have is courtroom experience, because for the most part, those of us who are state court judges have courtrooms full of people to serve.
Right.
And if you don't come through the trenches of representing clients and appearing in court and understanding procedure and how all of these things are mechanized, then you will be a fish out of water when you get into the court system, because each judge then has not only the courtroom and the people to serve, but also the clerk and the sheriff's deputies and all of the other components that make the court system run to think about. So it's not an elitist kind of work. It's a really hard, stressful occupation.
It seems like it. The little bit of experience I've had in it, on the right side, I've sat in the juror's box a couple times. I can't
Good
imagine, what's involved in it, and let alone trying to arrive at a fair decision and accurate decision, something that's based, let alone all the moving parts involved. So you apply to, who do you apply to for that? So you said you applied and then they say, yes, let's make you a judge. Who is that?
Well, let's distinguish that between
Okay.
circuit judges and associate judges. Now, in Illinois, our Constitution changed back in 1971, I think, and we had a position called a magistrate who wasn't really a full judge. So they reviewed those positions and they created something called an associate judge, and I believe that they grandfathered some of their magistrates into the associate judge position. And as you and I have chatted before we went on camera, there's always a dilemma about the independence of the judiciary, and it starts very early in the appointment or the election of judges in state court positions. What's better, electing people and having a political party be involved, or appointing people and having those who are aware of someone's experience, or conversely, someone who could be influenced,
Right.
take the bench. And so our system is kind of a hybrid in Illinois. We have elected circuit court judges, and you will see those names on our ballot coming
Right.
up for November 3rd. And those circuit judges are elected for 6-year terms. At the conclusion of 6 years, they are up for retention, and all of our electorate then decides whether or not they are still worthy of wearing the robe and serving the public. But the associate judges are not on a public ballot. The associate judges are periodically chosen by the circuit judges.
Okay.
So it's kind of a quasi-appointment elected position. And to go into that process, the county court, the chief judge of the county, has to announce that there are some vacancies in those positions that need to be filled. And then a process begins where applicants are reviewed by the Chicago Bar Association and other bar associations as to their qualifications. They're rated. And then if they are nominated, twice the number of candidates as there are vacancies are nominated. And what I remember from 1981, when I went through the process, was that I was literally trying to see every one of the sitting circuit judges in person to offer my hand and introduce myself and be available for questions. So it's kind of a mini version of the Supreme Court
Right, getting vetted
screening.
in some way, or
Right.
Yeah.
And sometimes they didn't have time to see us, but sometimes they were very interested in who we were. And of course, we had printed resumes at the time. And
right. I know it's not part of what you said. A couple things that I found interesting that I feel like I still want to pursue.
I'm so
a little
glad,
bit.
Dave.
Well, to me, talking about the hybrid system, I'm sure you're aware of this. One of the things, like, we're going to go vote, or some people are voting now, or have the mail-in ballot, and we look at all those judges, and I don't know who they are. I don't know what type of decisions they've made. Are they good or are they not? And typically in that situation, I'm like, well, what does the Tribune say, or what does my association say? Who do they recommend? So I'm turning over my trust to somebody else. That would be my one concern with the vote retention policy.
Because I've been retired for so long, I don't know
You
very
don't know
many
me
people
either.
on the list either. So I turned to the same group of people who vetted me as a candidate
Okay.
and reviewed me when I was up for retention every 4 years as an associate.
Okay.
And that's the Chicago Bar Association Judicial Evaluation Committee. And I owe them nothing. I just know that that process is is meticulous. Other bar associations, as they have proliferated in our community, also do reviews, and one could go to a website for the Justinian Society, which is Italian ancestral Bar Association, or the Women's Bar Association, or the Southwest Bar Association, and look for their evaluations, their recommendations, or their lack of them. And when folks ask me to help them with that, that's the only referral source that I use.
And I want to move into some of the other questions we have. I find this really interesting, though, because now that you said it, you reminded me. I did hear an interview where, and I think it was the Chicago Bar Association, or Chicago Board Association? Was
Bar
it?
Association.
Bar Association. And they talked about that website. And I'm going to, if you don't know, that's okay.
We can come back another time and talk about it.
Are these generally apolitical? Because as an outsider,
Yes.
my concern is, do they have an agenda? You know, like, is there a reason why they want him or her for that position?
It's apolitical.
It is, okay.
I have great confidence. They're a very hard group to please.
Okay.
So in order for someone to achieve what they call highly recommended, they're soliciting input from lawyers who are practicing in the court, and so they're listening to everything that everyone says without a political banner being attached to it. So if you're looking for someone to be recommended or highly recommended, if they're not recommended, particularly someone who's already been sitting,
yeah.
and those not recommended statuses can be reviewed in detail if you look more deeply into the website. So you could either have read about one of the not recommendation candidates in the paper, or if you just want to go and read what they have to say, they'll tell you. They write it out.
Okay, so you could go to one of their websites, like the Chicago Bar Association.
For
okay.
sure.
I did hear that, and if it was, I don't want to attribute to that organization, but that there were two, and I think the Tribune identified two justices that they were not
For
recommended.
very different reasons, that's all I want to say.
Right,
I know
yes,
one of the judges, and I don't know the other, so I really wouldn't want to say anything.
But, and let's maybe get back to what we thought we were going to talk about. There's a lot of different philosophies in interpreting the law, and this is where maybe state law and federal law diverge even more, right? Because federal law is wrapped itself around the Constitution. Is that a fair way to describe it, or no?
No, I wouldn't say.
Okay.
The Constitution oversees or is in the backdrop of everything that we do, both in state courts and in federal. As our country evolved and our legal system evolved, we wrote more laws down. In the beginning, we were just collecting the decisions that had been made previously, and that collection grew and grew and grew. But because human nature and human activities began to accelerate over the course of our country's existence, it was really clear that we needed to write some things down, and we call that black letter law.
Right.
And the black letter law is written in the U.S. Code. And that's what those representatives to Congress do. When a bill is finally signed into law by the president, then it becomes part of the U.S. Code, and many, many volumes of the U.S. Code. So that's a black letter law with the Constitution behind it. And then in our state, we have black letter law, but we always have both the Illinois Constitution and the U.S. Constitution as a backdrop. We shall not, as a state, exceed or limit the provisions of the United States Constitution.
Okay. Okay. All right. So I think I have a handle on that. So the laws that Congress writes all the time, that law exists out there, and sometimes it does bump into specific articles in the Constitution, for example, right? And that's where, like, the appellate court can be involved in other things, but they may be involved in that, or eventually the Supreme Court. Is that accurate?
I think that the United States Constitution is more often the topic in a Supreme Court hearing, and those are few and far between, as I know you know. You've been doing your reading. but the appellate court is not necessarily making each and every decision
Right.
about the correctness of a trial court decision.
The reviewing process.
The
right?
reviewing process, the reviewing a judge's decisions on
Right.
procedure and evidence and admitting things. This shouldn't have been admitted, this should have been admitted. So that appellate level is not so rarefied. The Supreme Court level, both in the state and federal court systems, that's where you, first of all, have fewer questions accepted, and they have the right to accept or reject petitions.
I've
And
seen
once
the numbers. It's incredible, the amount of number of cases that are applied, but the few they accept. I mean, it's
right, and they must be novel, and they must be certain types of issues that have great importance.
So maybe that's maybe that's the transition here. If you feel like I'm missing or creating a gap, please help jump in and we're okay.
Oh yeah, well,
Okay.
we're okay so far. It's just a big subject matter area.
It is.
Yeah.
It really is. And it's funny calling it a big subject matter, but as we were talking earlier, and I was doing my research on this, what's actually said about the judicial branch in the Constitution is very tiny. Article 2 mentions within the president's powers the ability to, or the authority to nominate somebody for a justice position. Article 3, Section 1, gives the Senate the right to appoint those judges, to officially confirm them. And it's almost literally that vague. I'm not going to read it, but it's relatively short, incredibly vague. I mean, do you want to comment on that at all? Because it seems compared to the other two branches, the judicial branch is much less defined.
Or you could also say much less governed.
Yes, it is. That's probably a better way to say it.
As we were previously discussing, at the inception, when the Constitution was written in 1787, and this government consisting of three separate institutions was being imagined. It was being imagined. Yeah. So there was not much there to flesh out the structure of a court system. They hadn't really decided about banking either at the
Right.
time. There were so many questions about the distinction between state and federal operations that were left to be decided, that the Constitution Article 3, the judicial article, that was left wide open for both interpretation and development. And so we came from an English legal tradition, but we didn't have our own colonial judges that weren't attached to the king's government. So we had to develop how we appointed judges or elected judges, and from then on, I'm certain that there's much more in the U.S. Code that would define how things operate. And then within the court itself, it's developed its own rules and regulations or its own traditions
Right.
for proceedings. But the one thing I think that we know from early on is that appointments to the Supreme Court, the United States Supreme Court, were going to be lifetime. And this was such a big debate, and the rest of the constitutional debate, it's kind of interesting that the founders were choosing away from lifetime president.
But the judges
But the judges were going to be lifetime. So I'm not sure if they thought there was such a small pool of potential judges out there from which to choose that they had to make those lifetime appointments, or if they really wanted those people to be unassailable,
Right.
unbiased, and never going to become any more biased than they were.
Right. That would seem to be the intent.
Well, it would seem to be the intent. We attribute a lot of really brilliant intellectual thinking to the representatives at the Constitutional Convention. And as I said, I mean, maybe they did know
Right.
that. Maybe they did think that. But it is kind of interesting that in the executive article, they definitely did not want the president to have a lifetime appointment.
Right.
Alexander Hamilton has famously argued for 6 hours that we ought to have a lifetime presidency, and not one of his finer hours. But
No,
we
didn't make it
get
into the
lifetime.
musical, I don't think, either.
Oh, yes, it did.
Him arguing for that?
Yeah. Yeah, you have to know where to look for it.
Okay,
But it's in
I'm gonna watch it again. Then I know I can get it on demand or something. And that was the thing that you were talking about now, like the lifetime appointment. You know, there was this kind of mind reading, like, well, what did the founding fathers intend? You know, that kind of mentality. But that kind of brings us to the process we have now. When just a little bit of context, so that when President Obama, in his fourth year, or his eighth year, his last year of his presidency, Justice Scalia passes away, and so there's 269 days left in his term, and the Senate decided at that time, well, we're not going to, in effect, look at a nominee in an election year like this. And I remember at the time, like, yes, I understand the politics involved, and I wondered, well, gosh, that seems like a long time to go without a justice. I mean, aren't there guidelines on this, And that process kind of played out, and we waited until after the election for another justice to be nominated. Or he nominated one, but for one to go before the Senate. And then now we're in a unique situation where, I'm going to call it a fast track, and I'm going to throw out some numbers why I feel like I can say that. We have a justice who's nominated, and she's going to go through in a much accelerated process compared to what other justices have gone through. So just a range of numbers here, not for any particular reason. I'll throw these out. Clarence Thomas, who was confirmed in 1991, I think, was a 99-day process from, through the vetting of it. John Roberts, our current Chief Justice, he was 62 days. Brett Kavanaugh, who went through the process just a couple years ago, he was 89 days. The average in modern history since 1971 is for a judge to go through this, nominee to go through this process from nomination to confirmation is 68 days. Okay, so we're going to be well under that if Justice Amy Coney Barrett gets confirmed. So it raised for me the question then, well, what is the process? Is there a process defined? And basically the Constitution does not address that. The Senate hearings don't need to take place, actually. There's no, it's a policy that they've adopted, it sounds like, right? A procedure they've adopted.
Right, is a part of their Senate tradition, and I'm not sure that it's made it to Senate rules.
Yeah, so
it's kind. I want to stay completely away from any political thinking or speaking here, but I do think that the rules probably change depending upon how much of a majority there is, and whether there's a majority in the both houses of Congress, or between the Senate and the President. I think the alignment is probably what gives a lot more force to an inclination to fast track something. Yes,
yeah, and I would agree with you. We can recognize the politics. I think my concern was, aren't there guidelines on this? And this goes back to the vagueness of Article 3. Matter of fact, it reminds me that, and you might know how many years ago, right now a simple majority will confirm her, but that was not the policy or that was not the practice up until a few years ago, I believe. Is that correct?
I don't know.
Yeah, I wish I could. All right, I'm going to put that on hold because I don't want to raise one I can't pin down like that. But
and it's no longer relevant. Whatever it was, I mean,
a simple majority is what's going to happen. So why is the vetting process that we've adopted, that she's going through now, why is that so important, though? Do we need to do it?
I'm not sure that we need to do all that we are doing. I mean, I'm not sure that all of the speeches that are being given sound in the nature of a vetting of the candidate. I completely agree. As I said earlier, the vetting by the Chicago Bar Association was very thorough and examined an individual's qualifications. Well, now with all of the media that we have at our command in the 21st century, it's not exactly a secret
Right.
who, you know, where a person went to school, how many kids
Right.
she has, et cetera, et cetera.
Decisions made.
These things are
Right.
instantaneously known to the voting public, as well as many other layers, the availability of her writings. But traditionally, going back to the history of our country, candidates were not known. There probably wouldn't have been anywhere near as instantaneous an understanding or accessibility of information about a candidate. So I tend to think that the history of sitting a person down and asking them questions had something to do with a lack of information
Right.
and the lack of availability of information on inquiry. Now we've built a very complex structure, and then we put it in front of cameras. And
Yeah.
so those who have run for office in the Senate are using this as an opportunity to prove to their constituents that they're working hard,
Yeah.
that they are trying to exemplify whatever the values common to their constituents are. Although it doesn't usually sound like they're speaking to their whole state worth of constituents, more of a party leaning. It still is being used as an opportunity to project rather than to discover,
Yeah.
with leaving the candidate, interestingly,
Yes.
sitting there
Silently listening to a long speech.
listening.
Yeah.
I did, however, hear questions being asked of the judge that I think could be justified as an inquiry into her thought process. How does she respond?
Right.
How, if she was pushed, and believe me, the courtroom experience often finds a judge being pushed. If she was pushed, what would her demeanor be? What would what would come out?
Right.
You know, the human nature that's present in all of us does sometimes have its button pushed
Right, reveal itself
so
in a.
here she is proving her mettle by being able to sit through all of this grandstanding, if you will, and listening, doing a lot of listening, and in that way she's proving something, and in other ways, as she appears to be pushed by some of the inquiries a little more than by others, she shows us her willingness to reveal any kind of a judicial temperament. Not that that's that important on the Supreme Court,
Yeah.
but there shouldn't be a problem with judicial
Right.
temperament. And so I guess the other thing I want to say is that some of those other longer hearings maybe had more to do with inquiring about a judicial temperament, or some of those famous cases were inquiring about a judge's morality. And I don't think that that's the case with Judge
Right.
Barrett at all.
There's more backstory on some of the judges, or there's more to
Well, right,
explore.
and backstory, the fairness about asking about backstory, particularly when the issue was previously sexual harassment. And two of the justices, is that backstory living in the person today?
Right.
Is that going to be a part of who that justice is for the rest of the lifetime appointment?
Right.
So, I mean, these are the people who stand for the highest level of judicial demeanor and respect of law, respect of morality, respect of neutrality, independence, and all of those things. And if a person has a tendency to deviate from those things, you better find out about it before they go on the
Right.
bench for life.
That's, we're kind of actually working into the next topic I wanted to talk with you about, because this has to do with the judge's, personal experiences, their background, their beliefs, which, has been part of the conversation, the hearings right now. I was listening to a news commentator the other day talk about, the two or the three branches of government. Two of them are very political, but the third one is supposed to be apolitical, right? That they are, they're kind of subject to, they bump into, they have to work with the other two very politically motivated branches, but theirs is different. And so I guess the question, maybe I'll be putting you on the spot, you don't have to comment on yourself, but to what extent, either your experience for you or what you see in other judges, does their personal belief or their personal experiences apply or impact? I guess as an outsider, I hope when I go into the courtroom that the judge is going to apply the law to the best of their ability, not necessarily base it on some personal,
Well, of course, don't we all? We all hope that.
Right.
You don't want to walk into a courtroom and then find that the person who is in charge of your case, whether there's a jury or not, is that person in charge of your case someone who harbors a deep hatred of people who wear glasses? I mean, you and I are in trouble if we walk in there. How would we know? So those kinds of things need to be sorted out. And usually if someone has a really powerful bias, it can be discovered, particularly in this day and age when we have access to so much information. But the fairness of our system, and that is above all what our judicial system holds as a value. The fairness of our system depends upon people being able to check their own personal beliefs, their values, their practices at the courtroom door. And although I can just say something of my own, and I don't want to say that it's the, I don't want to congratulate myself as I say it. It was just so present, so mechanical a part of my process that when I put my robe on and then walked to my courtroom door, I literally felt as though I were putting on a costume and that I was going into some kind of a play in which I, as an actor, would not be speaking my own lines. I would be projecting the script and the lines that were there for someone else, someone completely neutral. So we hope for that. And it was literally a part of my own preparation to go into the room. The neutrality has to be seen. It can't be announced. It has to be seen, and it's seen in a lot of different ways. That every single attorney in the room is treated exactly the same as the other person. Every single litigant is spoken to with exactly the same level of respect. That the people in the audience can see that the judge has no favorites, doesn't treat anyone lesser than. So there are subtle ways that people can see the neutrality, but otherwise, those of us who are searching for that overriding, most important value of fairness simply want to believe that it already exists. So when you walk in the door, you're not able to see all those little nuances I spoke of. You just want to believe it's there. And that's what we're supposed to be doing when we choose judges. Choose people who have the capacity to do that.
Yeah. And I agree with you 100%. This idea that that's what we want to believe in. That's what we're hoping for. That's what will allow the system to work, right? If they're able to fulfill that role that you're talking about, right? That's probably a good transition to one of our last questions here. Then is so the current nominee, Justice Barrett she's described herself as an originalist. I feel like I'm getting a civics lesson, all kinds of new, terms. I thought I paid attention in high school. I don't remember hearing some of these. What does it mean to be an originalist? How does that apply to her?
Well, she identifies herself as an originalist, and I am not really a student of Supreme Court opinions because I was working with families, and my references were not the United States Constitution as the first point of reference. But I do understand that originalists are there to adhere to those things that are written and identifiable in black letters in the Constitution, and not to deviate. I'm afraid that it's a relatively rigid perspective for judges who are using a document that was written in 1787 plus the amendments, the subsequent 26, I think, amendments, bringing us to current date it still is kind of a limited way to look at a society that has clearly evolved to embrace many more ways of thinking and being in the world
Right.
than were allowable in 1787. There weren't, after all, women being given a full set of rights in 1787.
Right.
So it's if you're going to fast forward to 2020, you had better have something more than your originalist hat on, because now we have women not only sitting on the court, but we have women in many positions of leadership and power, accepting that women are fully equal as human beings.
Right. It certainly does create a challenge there, because certainly in 1787 they couldn't picture exactly what the world was going to look like today. Which, and again, in my, in the research, you bump into terms like textualism and other philosophies involved in making decisions, whether it's based on precedent or moral reasoning. I've heard the term national identity for ethos, structuralism, historical practice. So they can be an originalist, and maybe some of these other factors will come into play depending on the decision they're facing, right? So maybe just as one contrast to, we talked about an originalist a little bit, somebody who's working with the Constitution, trying to apply and interpret the way it was intended when it was written, based on that population. What is a pragmatist then? How does that philosophy work?
Well, I find myself a pragmatist in whatever way I am working, and as a retired person, I'm still relatively a pragmatist. I mean, what is needed here? What gets the job done? What's fair? I'm part of my creative life is as a quilter. I find the quilters are very pragmatic. What gets the job done? Do you have this little piece of this over here that would fit into this? So as a sitting judge working with families, you're not asked to apply black letter law. It's not a matter of guilt and innocence or damages. You're always asked to solve problems. And so a person who does that for 19 years, as I did, becomes very pragmatic. Where's the pain in the family? Where's the root problem? What's going to solve the issue? And how do we address this in a practical way? And so I would have to say that if I were suddenly surprisingly elevated to the Supreme Court, that I would have to approach it with my pragmatic point of view. Now the thing...
And some justices do.
And some justices
on the
do.
Supreme Court do, yeah.
They have their reputations are superior for knowing what will fit into existing case law and respect for the accumulation of precedent, which is really, really important. In the background of every case is the precedent has been accumulated. But what I want to say about our current hearings is that it strikes me that Judge Barrett is, notwithstanding that I previously called it grandstanding, she is being exposed to many personal stories. And as these senators have used their photographs and charts and their 30 minutes of questioning to storytelling, as a judge on the Supreme Court, she would never hear those stories. She would never see those pictures, because Supreme Court proceedings have nothing to do with hearing the evidence or being acquainted with witnesses, nothing at all. And so here I see a woman who is a mother, a wife, as well as a professional woman. I see her being assaulted with some very personal, very intimate kinds of family information. And I'm sure she has a place in her personal life to put that information to have it concern. So I guess I'm hoping that there is that part of all of this hearing time that is for the good in a constructive, pragmatic way. She's seeing what she would never have seen or heard in the court.
That to me, as the layperson in this situation, seems like an incredibly daunting challenge for, especially in this case, the Supreme. Your job seems I can't imagine the things that you had to navigate. And now, this is a different type of thing, but to be a Supreme Court justice and kind of navigate, applying the Constitution, but being pragmatic, or, working with precedent, or, well, what are the values of our country? It seems like a lot.
It is, and they are a rarefied few people
Right.
with lifetime appointments and all sorts of respect and ascending to the highest levels of profession. They had better have a pretty hefty skill set and have the capacity to do all the work. I mean, Justice Ginsburg was a woman who had all sorts of physical problems, and yet she worked more hours a day than I probably ever worked in a single day. So dedicated was she to doing her public service, not to demean my own dedication or public service, but she found a capacity for work that was mind-blowing, extraordinary.
Yeah. This has been a heck of a conversation. And I almost feel like we've covered a lot, but at the same time, there's a lot more to cover here. I'm going to wrap it up.
Don't you hope, though, that the fact that you and I have had this conversation and shared it with our fellow residents is going to help them think about the things that are being broadcast, because there aren't that many people who are in a neutral way talking about the backdrop,
Right.
the backstory behind becoming a judge.
I hope so. I know for me, and I feel, yes, I read, I love history, I love studying this stuff, but I still feel like I'm learning quite a bit in this process. Judge Snow, Susan, thank you so much for sharing these insights. I mean, for me, this has been incredibly fascinating. It makes looking at this process that much more interesting. And I don't know if I could thank you enough for taking the time to spend this.
Oh, thank you for asking me. I really enjoy thinking about these things. I'm thinking about them anyway, so it's nice to be able to talk about them a little bit. But I do sincerely think it's important for young and old, all the range of our fellow citizens, to know a little bit more about how the process works, and for those who are considering a future in the law and who would aspire to being a judge, absolutely, they should have a better sense of how it works.
For sure. If the democracy is going to work, this is part of what we need to do.
Oh, please. The democracy is going to work.
Yeah. If it's going to work,
right? We all believe.
People need to know. People need to understand who's who and what's going on. And
Absolutely.
Thanks again.
You're welcome.
I'm Dave Wurzall. Thank you for watching Spotlight Issues, Becoming a Judge, and Interpreting the Law 2020. Thank you.